Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers reasonable suspicion, the knock and talk doctrine, and fighting words, and is brought to us by Rob Huff's channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into the interaction, I want to give a big thanks to the sponsor of this episode, Surfshark. Surfshark is a premier VPN service that offers unparalleled digital security for a fraction of the price of other competitors. We all know that Surfshark is one of the most secure VPN tunnels on the market, but a Surfshark subscription also allows its users to bypass region restrictions on popular platforms like YouTube and Netflix and view content that's not normally available in your country. Thanks to Surfshark, I can still catch my favorite episodes of Friends, even though it was removed from the US Netflix catalog. Surfshark also offers a ton of additional features to enhance your browsing experience and secure your connection. My personal favorite is the alternative ID feature, which generates a completely new identity and email address for you to use online without the risk of leaking your personal information. Right now, Surfshark is offering the ATA community 3 months of Surfshark for free when you use code AUDIT or click on the link in the description. With 24-hour customer service and a 30-day money-back guarantee, you have absolutely nothing to lose. So click on the link in the description and claim your exclusive offer now. Thanks again to Surfshark for sponsoring this episode. On May 13th, 2023, Deputy Hudson and another officer with the Sussex County Sheriff's Office pulled over local landowner Robert Huffman as he was driving near property he owns in Sussex County, Virginia. Mr. Huffman began to film the encounter shortly after he was stopped.
Hey, sir, how you doing?
We're doing fine. What's the problem?
I got a shooting range or something over there.
My property.
That's your property?
Yeah.
Okay, is people currently shooting over there now?
What's going on?
So we get a call of shots fired in the area. Listen, anytime shots fired in the area, you got your ID on you, sir?
I haven't committed a crime.
Right now, there's an investigation going on, sir, for
Watch
shots
yourself,
fired in
please.
the area, and I need to know who I made contact with. What's your name, sir?
My name's Rob. It's a pleasure to meet you, Hudson.
Okay.
Yes, sir.
All right. So we got a call of shots fired in the area. You say you own that land up there?
Yes, sir.
You live up there or just land?
Just land.
Anytime shots fired in the area, we got to come. If it's hunting, hunting time, we get a lot of calls. So
Okay.
we have to investigate because we don't know what's going on. So that's what I'm investigating. So again, you got your ID on you.
No, it's not illegal.
So I gotta make
I didn't break any laws.
Yeah, so we got a call of a red truck that shots fired in the area. So do
What
you
crime?
have shots fired in the area?
That's a crime?
Yes,
In
sir.
the county?
Ran the roadway and the houses in the area.
Oh,
Yes,
no,
sir.
no, it was never any.
Okay, I don't know that yet.
That's
I haven't
not
went
true.
back. The only thing I got is a red truck.
I'm just gonna exercise my Fifth Amendment right at this point.
Okay, that's fine. I need your ID though, sir.
I'm not gonna ID
right.
myself. I haven't broken the law.
Step out the vehicle for me, sir.
I don't consent to any searches or seizures.
I'm not searching vehicle. Right now, you must identify yourself, sir, because I have made contact and there's an
I haven't
ongoing
broken the
investigation.
law. I'm exercising my Fifth Amendment right.
You're refusing to identify yourself to me.
You haven't articulated a crime.
That land belongs to you.
Yes, sir.
Do you have any backstops behind any shooting that's going on back there?
I'm not going to answer any questions.
Okay, that's fine. Give me 1 second.
Can I see your supervisor?
He is a supervisor, sir.
I allow people to hunt on that property as well. So
Okay.
when they're hunting, is that a crime?
How much land you got?
I'm not going to answer any questions.
I'm just going to
Because I have a Fifth Amendment to the Constitution.
You want to assert your rights. I have no problem with
I'm
that.
being
Okay.
illegally detained at this point. I have no obligation to assist you in your investigation. The Fifth
I
Amendment
just
to the
want to know what your
Constitution.
issue is. Why you don't want to talk to us?
I
That's
don't
my
like
question.
police. I'm sorry. I think
Okay.
you guys are tyrants.
Okay. Well, technically we have enough to stop you for the incident that we're investigating. And technically, if you want to get into the aspects of the law, you're just driving down the road. We have a right to see your driver's license registration. There's
No.
Supreme Court case law on that.
Yeah, if I violated the law.
Okay.
What's the law?
Okay.
RAS, reasonable articulable suspicion. If you can articulate to me reasonable articulable suspicion, I will be happy to ID
So
myself.
if you want to play the reasonable person standard, we'll play that. I don't have to have a crime to stop you. I don't
Yes,
have to have a
you do.
crime to ID you. I don't have to have a crime to talk to you.
You have to have a crime. If I've done something wrong, I will ID myself. You tell me what I've done wrong, and I will ID
Show me
myself.
where in a law book anywhere that reasonable suspicion equals a crime.
The officers argue that they have reasonable suspicion to detain Mr. Huffman because they received a call that a red truck was seen in an area where shots had been fired, and that they do not, quote-unquote, need a crime in order to have reasonable suspicion. As we've discussed before on ATA, in order to detain an individual, an officer must have reasonable, articulable suspicion that they have been, are, or are about to be engaged in criminal activity. However, this does not necessarily mean that an individual must have actually broken the law or committed a crime in order for an officer to detain detain them. As the Supreme Court recognized in the 2000 case of Illinois versus Wardlow, a detention may be justified even if an individual's conduct is lawful, ambiguous, and susceptible of an innocent explanation if it also is suggestive of potential criminal activity, and that the infamous Terry case recognized that officers can detain individuals to resolve such ambiguities, arguing that, quote, in allowing such detentions, Terry accepts the risk that officers may stop innocent people. Therefore, a report of shots fired could serve as a basis of reasonable suspicion, even though some discharges of firearms may be legal, as shots fired could be potentially indicative of criminal activity. Nonetheless, in this situation, it is questionable whether a report that a truck was seen in an area where shots were heard would be sufficient to give the officers reasonable suspicion to pull over Mr. Huffman and detain him. In the 2011 case of U.S. versus Massenburg, the Fourth Circuit Court of Appeals, which has jurisdiction over Virginia, held that an anonymous tip that shots had been fired in a high-crime area in which random gunfire was typical was insufficient to support a Terry stop when the tip contained no physical description of the perpetrators, and the only link between the tip and the detained group of citizens was their rough proximity to the alleged site of the gunfire. Now, on the other hand, in the 2010 case of U.S. versus Monroe, the Fourth Circuit concluded that an officer was justified in initiating a traffic stop based on the similar broadcasted description of a vehicle that was suspected as being involved in a nearby robbery that had occurred a few minutes earlier. Additionally, in the 2021 case of McCormick versus Kershaw County Sheriff's Office, the U.S. District Court for the District of South Carolina noted that although at least one other circuit had determined that the fact that a vehicle matched the general make and color description of a vehicle involved in nearby criminal activity was insufficient to establish reasonable suspicion, there was no controlling authority in the Fourth Circuit that clearly established such a rule. In this situation, the officers had a description of Mr. Huffman's vehicle, but it was only reported as being in the vicinity of where the shots fired were heard, which in a rural neighborhood where hunting is common is not particularly strong evidence supporting a reasonable suspicion that its driver was involved in criminal activity. Without more information about the nature of the tip, such as if it was anonymous, it is challenging to predict whether a court would determine that the officers had reasonable suspicion to stop Mr. Huffman. But Mr. Huffman would certainly have an argument that the stop was not constitutional.
Is this Terry v. Ohio? Is this a Terry stop?
No, I don't think it's a Terry
There
stop.
you go.
Okay.
Am I free to leave?
You can't shoot within a certain feet of the homes. So if y'all are in violation of that, you will be charged. Okay?
There's still no crime.
Yes, it is a crime. You can't shoot within certain feet of a home,
So
sir.
how many feet was I in?
You're good to go, sir. Have a
All
good
right,
day.
thank you. Y'all take care. Stay safe.
After the officers allow Mr. Huffman to leave the traffic stop, they drive onto Mr. Huffman's nearby property, exit the vehicle, and approach his father, Michael Huffman, who was on the property with Mr. Huffman's permission. The exchange that followed was captured on Deputy Hudson's body camera.
How you doing? My name is Deputy Hudson with the Sussex Sheriff Department. Listen, sir. My name is Deputy Hudson with the Sussex Sheriff Department, sir. We got a complaint from a neighbor right here, and right here.
Get over it. We're out here. We're 200 yards from anything near us, and we're firing into the ground.
You gonna let me talk, or you gonna finish?
I'm gonna finish. You are trespassing. You are not allowed on this property. The gate was closed.
Sir, you got your ID on you?
I don't have to give you ID. The Constitution says I don't have to give you an ID unless I have broken a law.
Do y'all own this residence right here, sir?
Yes.
Who owns it?
My son and I own it.
Okay, what's your name?
Again,
I don't know if you trespass or not. What's your name, sir?
my name is.
Your son's on it.
We our family own it.
Okay, so did he give you permission to come out here? Did he give you permission to be out here?
Yes, he has. But I have permission. You don't get to my property.
So he gave you permission to be out here, sir?
Yes.
Be
Did
out
you
here,
or
sir.
did you not pull
Sir,
him
did
over?
he
Not
give
5
permission?
minutes
No,
ago.
he didn't identify himself. I don't know who he is. Did he give you permission to be out here, sir?
I have permission to be
Can
on
you
my
call-
own property.
Can you call and verify that he gave you permission?
And I've been telling him the same thing. To get
So who's the owner of the property?
He is.
What's
Get
his
the
name?
off my property.
What's his name, sir?
Get the off my property.
You have your ID on you, sir? So we're trying to figure out who property this belongs because it looks like some abandoned property.
I've got.
Do you have your ID on you, sir?
I don't need an ID.
Sir, I can't leave right now because of the open investigation.
You're trespassing.
Sir, you might want to calm down before you go to jail, sir. You might want to calm down. Well, if he owns it, he needs to come back and show his ID. Okay, that's
You heard
fine.
that? Get the hell off my property.
Sir, turn around, put your hands behind your back. Turn around, put your hands behind your back for destruction and not cooperating with law enforcement.
When the elder Mr. Huffman refuses to identify himself and tells the officers to get off the property, Deputy Hudson places him under arrest for, and I'm quoting, obstruction and not cooperating with law enforcement. Virginia does not have a stop and identify statute that requires individuals who are not driving a vehicle to identify themselves to officers during Terry stops, and failing to identify does not violate Virginia's obstruction statute, which is found in section 18.2-460 of the Virginia Code. Although the statute states that, quote, if any person without just cause knowingly obstructs any law enforcement officer in the performance of his duties, he is guilty of a Class 1 misdemeanor, Virginia courts have construed the term obstructs more narrowly than some other states have. As the Court of Appeals of Virginia explained in the 1998 case of Ruckman versus Commonwealth, quote, to constitute an obstruction of an officer in the performance of his duty, it is not necessary that there be an actual or technical assault upon the officer, but there must be acts clearly indicating an intention on the part of the accused to prevent the officer from performing his duty. As to obstruct ordinarily implies opposition or resistance by direct action. It means to obstruct the officer himself, not merely to oppose or impede the process with which the officer is armed. Further, the court also noted that, now quoting again, there is a broad distinction between avoidance and resistance or opposition, and that, quote, obstruction of justice does not occur when a person fails to cooperate fully with an officer, or when the person's conduct merely renders the officer's task more difficult, but does not impede or prevent the officer from performing that task. Based in part on this precedent, the Attorney General of Virginia concluded in Official Opinion 02.082 issued on October 10, 2002, that, quote, a law enforcement officer, even when armed with reasonable suspicion that criminal activity may be occurring, may not arrest a suspect for obstruction of justice on the basis that the suspect refuses to identify himself. Therefore, it is highly likely that a court would conclude that Mr. Huffman could not be legally arrested for refusing to identify himself or, quote-unquote, cooperate with the officer's investigation.
This is my question, Mr. Huffman. Are you ready to talk yet?
About what?
The property. This is the thing.
Like I said, my son's wife was raised in that trailer
And
right there
listen,
all of her life.
So
I tried to explain it to anyone.
did you give me your ID? We had to basically go through this whole process. So check this out. Somebody comes out here and shoot on your property, right? I come out here, I say, hey, why are you shooting out here? This is my property. I let them go. You call the police and say, hey, somebody was shooting out there. Guess what? I don't have their ID. I don't have the information, so now I'm not able to identify that it was on your property.
Whatever happened to you not trespassing on the property?
We got a call and we have to follow through. So that gives us our suit to arrive on the property.
So you can cross gates and you can go...
Yes, sir, and investigation. Yes, sir.
I did not know that.
Deputy Hudson claims that the officers were permitted to open the gate to enter Mr. Huffman's property because they were engaged in an investigation. The Fourth Amendment prohibits officers from conducting unreasonable searches of private property. However, while officers are not always within their authority to open gates, there are a variety of situations where courts have determined that officers did not violate the Fourth Amendment by opening a gate and entering private property without a warrant. For instance, in the 1984 case of Oliver versus United States, the Supreme Court concluded that narcotics agents did not violate the Fourth Amendment, or even conduct a Fourth Amendment search, when they walked around a locked gate with a no trespassing sign to enter a quote-unquote open field, arguing that, now quoting, because fences or no trespassing signs do not effectively bar the public from viewing open fields, the asserted expectation of privacy in open fields is not one that society recognizes as reasonable. The court also determined that whether or not the officer's actions would be considered trespassing was not dispositive in the analysis, because, now quoting, the law of trespass forbids intrusions upon land that the Fourth Amendment would not prescribe. For trespass law extends to instances where the exercise of the right to exclude vindicates no legitimate privacy interest. On the other hand, as the Supreme Court explained in the 1987 case of United States versus Dunn, the Fourth Amendment does protect so-called curtilage, which is the area immediately surrounding the home. In the Dunn case, the court identified 4 factors that courts should use to decide whether property is part of the curtilage of a home or an open field. Now quoting, the proximity of the area to the home, whether the area is within an enclosure surrounding the home, the nature and uses to which the area is put, and the steps taken by the resident to protect the area from observation by passers-by. In this situation, it seems more likely that a court would find that the driveway was curtilage rather than an open field, given the fact that it was enclosed with a gate and appeared to be fairly close to the home structure, although additionally additional facts could alter this analysis. However, even if a court concluded that the officers entered onto curtilage, it could still determine that they did not violate the Fourth Amendment under the so-called knock and talk doctrine, which permits officers to enter the curtilage of a home to knock on an individual's door or attempt to speak with a resident without a warrant. As the Supreme Court explained in the 2013 case of Florida versus Jardines, quote, "The knocker on the front door is treated as an invitation or license to attempt an entry." And, now quoting again, "This implicit license typically permits the visitor to approach the home by the front path, knock promptly, wait briefly to be received, and then, absent invitation to linger longer, leave." Thus, a police officer not armed with a warrant may approach a home and knock, precisely because that is no more than any private citizen might do. Although it may seem that this implicit license would not extend to opening a gate to enter enclosed property, as the U.S. District Court for the Western District of Virginia noted in the 2013 case of U.S. versus Jones, quote, "The Fourth Circuit has made it exceedingly difficult for a homeowner to withdraw the implicit consent which underpins the knock and talk rule." In support of this contention, the court cited the 2004 case of Edens versus Kennedy, where the Fourth Circuit held that, quote, "If the owner of a home encloses the curtilage with a fence, locks the gate, and posts no trespassing signs, the effect for Fourth Amendment purposes is to extend the walls of the home to the edge of the curtilage. Therefore, unless the gate was locked and no trespassing signs were posted, it seems likely that a court would conclude that the officers did not violate the Fourth Amendment by opening the gate to enter the property and speak with Mr. Huffman."
You're trespassing. I want you off my property.
You the owner of this property?
I'm not answering any questions.
Okay, sir. Well, I don't know if you're the owner of the property. Please step back away from me,
Who's
sir.
trespassing?
Are you the owner of this property?
You're the only one.
Are you the owner of this property,
I'm
sir?
not answering any of your
Okay, that's fine.
Oh, so you're gonna arrest my father?
Do you have your ID on you, sir?
I'm not answering any.
Okay, well, I'm gonna ask you to leave, sir, if you're not the owner of this property.
Okay, I'm the owner of the property.
Okay, then do you have your ID so I can identify that you're the owner of the property?
No.
No.
How you gonna kick me off my property?
Because you're not identifying yourself that
I
you're the
don't
owner of this
have to.
property. That's fine,
I
sir.
don't have
So I'm gonna ask
to.
you to get in your truck and leave, sir.
No, I'm asking you to leave.
Are
I'm not
you
answering
the
any
owner of the
questions. I wanna
property?
see your
So at this time,
supervisor,
sir, if you're not
Hudson.
willing to
I wanna
identify
see your-
yourself,
I
I'm gonna
wanna
ask you
see
to
your
leave, sir.
supervisor, Hudson.
Okay, turn around, put your hands behind your back, sir. Thank you.
I want to see your supervisor.
Right now, you're being detained, sir, so
For
we can identify
trespassing?
you, sir. No, I'm
For
not. No,
trespassing?
sir.
So
Why
how
we got him?
Are you?
Do you have any weapons on you?
Yes, I do.
What
I
you
have a 9mm Glock on my right side.
Okay. I'm going to
Why
is
don't
it one
you
in the
not
head?
muzzle flash?
Is it one in the head?
Come here and videotape these guys.
Stand right here, sir, and stop.
Lean against the car for me, please.
Stand right here, sir.
Stand right there and relax, okay?
Don't muzzle flash.
Stand right here, sir.
You don't know how to use
Stand right here, sir, and calm down.
Please.
Calm down.
Please.
You're moving
You're not
back,
being
sir.
compliant, sir.
You're not being
You're not being
compliant.
compliant.
I'm
Okay.
complying. You fucking pointed that gun at me.
Sir, stop cursing at me
It's
before you
low-
receive a charge.
I have the freedom of speech.
No, you
okay?
don't.
I don't have the freedom of speech on my property. Video record this, Alec, Jared.
You got anything on you that's gonna poke me, stick me, or hurt me, sir?
Yeah, I got these nuts in your mouth. You pointed a gun at me, you dumb.
What's the name?
These nuts in your mouth, fat boy. Y'all's, I'm gonna get y'all's fucking cameras too. Is that thing on?
Is it
Yeah.
your property?
Yes.
You got anything to prove it is your property?
My wife sent me the deed on my phone that you confiscated without a warrant.
No, I don't.
Oh, you think it's funny? You see, you guys are lowlifes, man, and you're proud of yourself. Didn't you swear an oath to the Constitution?
All right, so you have a right to remain silent. Anything you say will and can be used against you.
So, Mr. Huffman, if we could just establish that the property's yours, and if you can do that easily by showing us the deed on your phone, that would greatly help our situation out.
So do you have that?
Yeah, have it on your phone. The
Okay.
one that you
We'll
took
get
from me,
out of
Hudson.
investigative detention, and we'll do what we have to do, okay? All we're looking for is a little compliance. That's all,
You don't
please,
get
sir.
any compliance.
Do you have the deed and
I'll
you
show
willing to
you
show us
the
the
fucking deed, Hudson, you low-life piece of shit.
This time, sir, you're gonna be charged.
You're going to charge me with trespassing on my own property?
No, I'm charging you for your verbal abuse.
Oh,
and your
that's the
profane
First
language
Amendment
use.
to the Constitution.
No.
I'm on my property. The first, are you aware? Are you familiar
Sir,
with
let's
the First
hey,
Amendment?
listen, sir. Let's cut
You
it
don't know
short.
the
There's
First
nothing else to say,
Amendment?
sir. Turn around right here,
That's
sir,
the
and
first-
just wait till a supervisor
That's
get
the
here.
First Amendment. It's freedom of speech.
Sir,
I can say anything I want.
You're right.
You
you're
just
right.
said you're arresting me
You're right, sir.
for using foul language.
You're right, sir.
When Mr. Huffman directs a profanity at Deputy Hudson, he informs Mr. Huffman that he's going to charge him for his quote-unquote verbal abuse. Section 18.2-416 of the Virginia Code states that, quote, "If any person shall, in the presence or hearing of another, curse or abuse such other person, or use any violent abusive language to such person concerning himself or any of his relations, or otherwise use such language under circumstances reasonably calculated to provoke a breach of the peace, he shall be guilty of a Class 3 misdemeanor. However, in the 1973 case of Mercer versus Winston, in order to ensure that prosecutions under this statute did not violate the U.S. Constitution, the Supreme Court of Virginia limited its application to so-called fighting words, or, now quoting, words that have a direct tendency to cause acts of violence by the person to whom individually the remark is addressed, as this category of speech is not considered to be protected by the First Amendment. For this reason, the Fourth Circuit Court of Appeals concluded in the 2021 case of U.S. versus Bartow that an individual could not be convicted of violating this statute for using a racial slur when the government did not prove that the individuals to which the slur was directed actually responded violently, or that a reasonable person in their positions would have done so, despite acknowledging that, quote, the ugly racial epithet used undoubtedly constituted extremely abusive language. Additionally, it is important to note that Mr. Huffman's allegedly abusive language was directed at a law enforcement officer, and as we have discussed before here on ATA, the Supreme Court explained in the 1987 case of Houston versus Hill that, quote, the First Amendment protects a significant amount of verbal criticism and challenge directed at police officers, and that it is, now quoting again, protected against censorship or punishment, unless shown likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest. In the Hill case, the court also favorably cited Justice Powell's concurring opinion in the 1974 case of Lewis versus City of New Orleans, where he, now quoting, suggested that even the fighting words exception might require a narrower application in cases involving words addressed to a police officer, because a properly trained officer may reasonably be expected to exercise a higher degree of restraint than the average citizen, and thus be less likely to respond belligerently to fighting words. Applying these principles, the Court of Appeals of Virginia held in the 2000 case of Martilla versus City of Lynchburg that an individual could not be convicted for using abusive language against police officers when he directed derogatory and profanity-ridden insults at them, concluding that the evidence was insufficient to prove that these statements, now quoting, had a direct tendency to provoke an immediate breach of the peace by reasonably trained police officers in the position of the officers to whom the remarks were addressed. In support of its decision, the court argued that, quote, this is precisely the type of verbal criticism of police officers that is protected against censorship or punishment by the First Amendment, because it is not, under the circumstances established by the record, likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest. Accordingly, it is highly probable that a court would conclude that Mr. Huffman could not be convicted of a violation of abusive language for his speech, as a well-trained police officer would not be incited to violence by his use of profanity or his insults, and Deputy Hudson did not appear to be actually physically provoked by his language.
Bobby, shut up. He's just jumping at straws to have some way to be a big man.
Yes, sir. Okay. Where's the name, man? All right, we're gonna finish this up and they'll be on their way. She showed us the deed. Get this paperwork. No, I'm not. I'm gotta
You're gonna violate his right
stroke this stuff. Cool. I'm charging him though.
Okay.
Why you charging him?
All right, so this is what we can do, sir. I can stroke you a summons and let you go, or you continue to talk. I can take you to the jail and take you in front of magistrate.
I just want to know, I want you to write on that sentence what law I have broken. Because I have not broken any law.
After determining that Mr. Huffman was the lawful owner of the property, Deputy Hudson issued citations to both Huffmans for using abusive language in violation of Section 18.2-416 of the Virginia Code. As of the date of writing this episode, both charges are still pending. It is unclear whether the Huffmans have filed a complaint or intend to pursue legal action for any violations that occurred during this encounter. Overall, Deputy Hudson and the other Sussex County officer get an F for maintaining a hostile and confrontational demeanor throughout the encounter, repeatedly exceeding the bounds of their legal authority, and arresting the Huffmans for conduct that Virginia law has made unambiguously clear is not illegal. Although Deputy Hudson eventually cited the elder Mr. Huffman for using abusive language, he originally informed him that he had been placed under arrest for obstruction and refusing to cooperate with law enforcement, despite clear Virginia precedent and an opinion from the Virginia Attorney General stating that individuals cannot be arrested for refusing to identify, and that obstruction requires was more than a failure to cooperate with law enforcement. Deputy Hudson also chose to arrest the younger Mr. Huffman for his speech, which, albeit offensive, did not rise to the level of unprotected fighting words and posed no danger to society, beyond potentially inflicting a light bruising to Deputy Hudson's self-esteem. Throughout this interaction, Deputy Hudson chose to prioritize his own ego over the requirements of the Constitution, and likely violated the Huffmans' rights in the process. The Huffmans get an A- because although they demonstrated some level of confusion regarding the legal contours surrounding reasonable suspicion and when officers may enter property, they firmly asserted their constitutional rights and confronted the officers for their blatant disregard for the First Amendment. While the Huffmans certainly could have chosen to use less colorful language to express their distaste for the officers' actions, they were well within their constitutional rights and engaging in protected speech throughout the encounter. And I commend Mr. Huffman for sharing this interaction on his YouTube channel and for encouraging his viewers to contact the Sussex County Sheriff's Office to express their disagreement with the officer's actions. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.